Hello friends, welcome back to my YouTube channel that is Discourse on Law and Politics. So on this YouTube channel that is Discourse on Law and Politics, we are going to solve the question paper of UPPCS of 2022. That means the examination which took place on the 12th February 2023. So we are having this series D here, the solving the question paper here, and you can see the question paper is like this. It is of the 300 marks. Total number of questions is of the 150. There would be 4 kind of the option would be given, and you can use the black ballpoint pen here. So this kind of the way you will find that the question, and there would be the negative marking, and it is of the 1/3 marking. Okay, so we need to be very careful while answering the question. So let's start this question paper here. So the first question which is here, you all can see, arrange the following in chronological order on the basis of sections of Criminal Procedure Code. So the question which is here, it is demanding that we need to arrange the chronological order, the sections of the CRPC. So chronological order means, you know, that it is that which comes first and then which comes at the last. So basically, normally we use the chronological order to for the year and all these things, but here they had asked question in the chronological order, so we have to answer that which section comes first and which section comes later on. So let's see, and the options which are given here: public prosecutor, special metropolitan magistrate, special judicial magistrate, and the court of session. So let's start. Which section talks about public prosecutor, which section talks about the special metropolitan magistrate, and which section talks about the court of session. Let's see one by one. So you can see the public prosecutor is section 24, court of session is section 9, special judicial magistrate in section 13, and special metropolitan magistrate in the section 18. So if you just arrange that, then the fourth will come first. Then you will find that the third will come next, and then second will come the third one, and the public prosecutor will come at the last. So that means it is going to have a combination of this: fourth, third, second, and one. And where is the right answer? The right answer is here, the option A. Okay, and you also can see there is also the Hindi. In Hindi, the question paper is given here, so it is a deglot paper. Okay, the next question is that when the accused is agreed by the report of psychologist to as his unsoundness of mind, he may appeal to where? For example, when accused person is not happy with the report of psychologist, then where he can appeal to this? And the options which are given here, that is, you can see here, the medical board, then the magistrate hearing the case, then the high court, and then the session court. And for that you can refer to section 328A 1A of the CRPC, and you need to see the proviso clause. And the answer of this one is the medical board. So this is how you can find that. I'm just highlighting the right answer, medical board. Okay, see the next question. We have to see which is not correctly matched. In UP Judiciary, you also find that most of the question they are asking in terms of matching, which is not correctly matched and which statement is not correct written. So that kind of question is coming this time also. They have asked this question. Now here you can see the name of the books, and on the other side you can find the name of the authors. So Leviathan was written by Hobbes. Yes, it is correct. Law, Liberty and Morality is not written by Fuller. It was written by the H.L.A. Hart. So this is how you can find social contract through the law. It is by the Roscoe Pound. Reverse of social motion is also by the hearing. So the right answer of this, the right options, that means which is for this question is here. That is, you can find this one, Law, Liberty and Morality, that is by the Fuller. Moving to the next question. This is question again from jurisprudence. Jurisprudence is the scientific synthesis of essential principle of law. This question is a repetitive question. It was already asked in the previous years as well. Now the options which are given here, you can see Professor Allen, H.L.A. Hart, Keaton, and E.W. Patterson. And the right answer of this question is here. HLA Hart said so. Sorry, Allen has said so. Okay. So Professor Allen had said that jurisprudence is the scientific synthesis of essential principle of law. Now moving to the next question. And this question is this here. A hangman who hanged the prisoner pursuant to the order of the court is exempted from the criminal liability by virtue of which section? So where a hangman is there and he has hanged someone as the prisoner, he will be exempted from the criminal liability, but under which section of the IPC? The options which are given: section 77 of the IPC, 73 of the IPC, 76 of the IPC, and 78 of the IPC. So which is the right answer? Just give your answer if you have the answer to this question. I am waiting for this. Yes, this 78 protects the person who work in consonance with the law. Okay, this is how you can see here. Now the next question is again, it is the matching the list 1 and list 2. So on the list 1 side you can find the specific provisions, specific sections of the IPC. On the list 2 you can see the specific provisions of the IPC. And now we have to do a matching of this one. So you all know that. How can we do this? Just a second. So 120A is about the criminal conspiracy, 124A is about the sedition, 295A is about the deliberate and malicious act intended to outrage religious feeling or any class by insulting religious belief or religion. So when you are making some kind of a statement so that someone's belief and religious belief is going to be hurt, then this section 295A is going to apply. So when the case of Nupur Tiwari was happened, this section was very highlighted at that time. Then this 354C is about the voyeurism, that if you are seeing a woman ostensibly, or you are seeing the women secretly, and then that is also a part of voyeurism. So if you just see this one, you can find that the option which is going to be here, for A it is to be the 3, for B it is going to be 2, for 295A it is going to be 4, for 354C it is going to be 2. Sorry, again let me clear. Yes, again for 120A is the 3, 124A is 1, 295A is 4, and D which is here, that is 2. So we have to see 3, 1, 4, 2. So where is the answer? The answer is here, 3, 1, 4, 2, that is B. Okay, next again it is a matching list. You can find the matching the list. So you can see here the provision of the Indian Contract Act has been given, and on sections of the Indian Contract Act has been discussed, and on the other side you can find the provisions of the Indian Contract Act has been mentioned. So we have to do the matching of these provisions and sections here. So let's see one by one. So just correct here, section 16 of the Indian Contract Act, it talks about the undue influence. Okay, section 71 is about the finder of goods. Section 2D is about the consideration, and section 56 is about the agreement to the impossible act. So now let's see which is the correct. So for A you can find that the 3, for B you can find that it is 4, for C you can find the 1, and for 56, that is D, you can find that the agreement to do the impossible act, that is the 2. So the answer is 3, 4, 1, 2. So which is the correct here? Just give your answer here. And the right answer is here, you can see A. The A is the correct. Okay, so this is the right option. Now let's see the next question. The next question is, which of the following is not correctly matched? So we have to see which is not correctly matched here. And you can see professional communication, it is in the section 126. Yes, it is correctly matched. Confidential communication with the legal advisors, section 127, it is not correctly matched. Matrimonial communication with section 122 of Indian Evidence Act, yes, it is correctly matched. Official communication, it is also in section 124 of the Indian Evidence Act, it is correctly matched. So which is not correctly matched? Which one of them is not correct in math? That is the B here. This is the way you can find. Moving to the next question. The next question is here. That is with respect to one statement. The statement, in order to constitute confession under the Indian Evidence Act, must either admit in terms the offense or at any rate substantially all the facts which constitute the offense. So it is about that the confession under the Indian Evidence Act must either admit in terms the offense or at any rate substantially all the facts which constitute the offense. So that is how the definition, how the confession is to be taken, how confession is to be considered. Okay, so then this is judgment with respect to Privy Council here. You can see, and the option in which case it was held, the Q.E. Abdullah, the first of A option. The B option is John McCain versus Attorney General. C. H.H.B. Gill versus King Emperor. And D. Pakala Narayan Swamy versus Emperor. So my dear friend, this is a question and the case is very important, and that is the Pakala Narayan Swamy. This is the, or someone called it Pakala Narayan Swamy. This is how you can find this. So in this case, the Privy Council had said this statement. Moving to the next question. The next question is again matching of the list. You can see it is matching of the list. List A, list 1 is about the you can say that the provisions. List 2 has the sections. So we have to match this one. So let's start here. So what you find, the first one is here, that is interpretation clause. So the interpretation clause is within the section 3 of the Indian Evidence Act. Then when facts not otherwise relevant becomes the relevant, then it is section 11 of the Indian Evidence Act. Then burden of proof is in the section 105 of the Indian Evidence Act. And the relevance of facts forming the part of the same transaction, it is in the section 6. So this is how you can find that. So it is being called a res geste. Section 11 is called plea of LB. So this is how you can find this. Okay. So now, which is the right option here for this? Which is the proper right code here? We have to see the right code here. So for A, you can find that it is the 4. And for B, it is the 3. For C, it is the 2. And for D, it is 1. So it is 4, 3, 2, 1. And where is the answer? Answer is here 4, 3, 2, 1. So okay. So this is the correct option. Now let's see the next question. So again you can see the next question is about the matching the list. So the questions are coming so much from the matching the list. So therefore, my dear friends, for the UP prelims, we all need to know the provisions and the sections, so that we can have a proper, we can solve the questions also here. Okay, let's see. So you can see the list 1 has the sections, and list 2 is about the having the provisions. Okay, so let's do the matching here. So you can see section 463 is given here. Section 463 belongs to the forgery. Okay, so for A it is 2. Then section 445, it belongs to the housebreaking. So for the B it becomes 4. Section 441, it belongs to the criminal trespass. So for that it becomes 1. And section 503 of the IPC, it is about the criminal intimidation. And for that you find that the 3. So this is the correct code. And we have to see where it is the correct code. 2413, you can see here 2413. Where is the 2413? We have to see, yes, 2413 is in the D. So this is the right answer. Next question is here. The headquarter of the World Intellectual Property Organization, where it is located. So my dear friends, I have made a video on this one where I had discussed about the UN organizations and its agencies. So I had covered this aspect in my one video. You can go to that one and you can visit there. So what you find that where the headquarter of the WIPO, World Intellectual Property Organization, it is being called in the brief or abbreviation as a WIPO. So where it is this? It is in the Geneva. Next question is here. Which one of the following principle is laid down in the case of Rajesh Kant Roy versus Santi Devi? And the options which are given: the principle of least pendants, principle of contingent interest, principle of vested interest, principle of part performance. So which is the right answer? So the right answer of this question is here, principle of vested interest. This case belongs to the principle of vested interest. Moving to the next question. Who is given protection from arrest under section 45 of the CRPC of the 1973? The options which are given: judicial officers, member of parliament, president of India, members of armed force. Which is the right answer? It is the question from the arrest. So the right answer of this question is, the right answer of this is, the right answer of this, who is protected, that is the members of armed forces. Okay. Next question. Movable property under section 2 clause 13 of the CPC includes. So what is the definition of section 2 clause 13 of CPC with respect to movable property? So under section 2 clause 13 of CPC, movable property includes the options which are given: buildings, growing trees, growing crops, and money. Which is the right answer? Just give your answer through the comment box. I am waiting for a response. The right answer of this question is this, the growing crops. Okay. Next question. The next question is here. Taylor versus Caldwell. Taylor versus Caldwell is a leading case on which topic in Indian Contract Act. Okay. The options which are given: doctrine of necessity, offer, doctrine of frustration, contingent contract. So which is the right answer here? The right answer of this question is, this case, Taylor versus Caldwell, is belonging to the case doctrine of frustration. Okay, so this is the right answer. Moving to the next question. The next question is here again. It is about the matching the list. So list 1 is having the provisions and list 2 having the case laws. So we have to see the which is matching here. So provision and case laws. Okay. So let's start one by one. So duty to register a FIR, it was discussed in the case of Rajinder Singh Katoj versus Chandigarh. Latches in investigation, it is in Krishnan Govada versus State of Karnataka. Faulty investigation is in the Saju Mohammed versus State of Kerala. And delay in examination of witnesses, it is in the Surjit Sarkar versus State of West Bengal. But I have some doubts whether this is the rightly matched or not, but as per the rest of the things are properly matched here. So I think the answer which is going to come here, that is the one for A it is 1, for B it is 2, for C it is going to be 3, and for D it is going to 4. So that is 1, 2, 3, 4. This is the right option. Okay, and where it is this? And it is in the option D. Next question is again also with the matching the list. So you can see here, match list 1 and list 2. So list 1 has the certain theories, list 2 has the jurist. So the first is purpose theory, will theory, fiction theory, listic theory, Salmon, Geerk, Ehring, and Austin. My dear friend, this question had been asked already also. That means in the previous years, this question was asked. So now let's start the matching here. So here you can see, firstly we will start here from the fiction theory. Fiction theory is belonging to the Salmon. Okay. Then come to the realist theory. It is belonging to Geerk, or someone called it as Geerke. Okay. Then come to the will theory. Will theory is a part of the Ehrings, and the purpose theory is about the Austin. So what you can find that if you just see the answer here, that means A is going to be a part of the 4, B is going to part of 3, C is going to part of 1, and D is going to part of 2. So this is how you can find it. The answer is 4, 3, 1, 2, and this is the right code here. So which is the right code here? A is the right code here. Okay, so this is the correct answer. The next question is here. Again, it is a matching the list. So many questions are coming from the matching the list. Very interesting. So you all need to know about the provisions, sections, and articles. Now this is from the international law here, and particularly it is about the UN Charter. You can see. So we have to see. List 1 is about having certain provisions. List 2 has the articles. List 2 has the provisions. Okay. So this is how you can see. Let's start the matching here one by one. So the Article 2 Clause 7 of the UN Charter, it is about the domestic jurisdiction clause. So for A, it becomes the 4. Okay. Then Article 4 Clause 2 of the UN Charter, it belongs to admission of a state into the UN. So for that B, it becomes the 2. Now coming to this section, Article 33. There is need to some change here. It is 1. So for A it is 4, B for 1. Now coming to Article 33 UN Charter. For this you can see here, it belongs to the pacific settlement of disputes. So this is for the 2. And then come to this Article 36 Clause 3. It belongs to legal disputes to be submitted to International Court of Justice. And for that it belongs to 3. So 4, 1, 2 and 3. This is the proper correct code. So let's see which is the proper code here. 4, 1, 2, 3. A is not here. 4, 2, 1, 3 is this. It is 3, 2, 1. B is also not. And C 4, 1, 2, 3. Yes, this is the correct. So C is the correct answer. Now let's see the next question. So let's see this question. You can see again it is matching the list. So many questions are coming from matching the list. So the first list is about the bodies of the UN, and list 2 is about the provisions, articles, okay, of the UN Charter. Let's start the matching here. So composition of General Assembly is in the section 9. Composition of the Security Council, it is in section 23. Composition of Economic and Social Council, it is in Article 61. And composition of Trustee Council, it is in the Article 86. So therefore what you find that for A it becomes 1, for B it becomes 4, for composition of Economic and Social Council it becomes 2, and for trusteeship it becomes the 3. So 1, 4, 2, 3. This is the proper correct code. So which is the answer here? So if you just go to the A, you can see that it is not like that 1, 4, 2, 3. B is also not like 1, 2, 4, 3, 1, 4, 2, 3. C is having the 2, 3, 4, 1. Therefore it is not like this. And this is the last one. Yes, it is the correct. So D is having 1, 4, 2, 3. Okay. Now let's see the next question. Again, it is the matching of the list. So you can see match the list. List 2, list 1 has the provisions. List 2 has the sections. So let's start the matching here. And this question is from the TPA here. So start here. So you can find that the gift belongs to the section 122. Contingent interest belongs to section 21. Marshalling belonging to section 81. Sales belong to section 54. So what you find the right answer of this question is sale. For A it is going to 3. For B it is going to 4. For C it is going to be 2. For D it is going to be 1. So we have to see the correct code is 3, 4, 2, 1. So where is the answer here? Let's see here. The right code is here. You can see 3, 4, 2, 1 is in the A. So this is the correct code and this is the correct option. Again, the next question is also about the matching the list 1 and list 2. And now you can see on the list 1 there are certain provisions, and also in list 2 there are certain kinds of the transfer of properties, types of the transfer of properties. It has been discussed. So let's start here one by one and do the matching here. So what you can see here, redemption which is given here, it is belonging to the mortgage. So C belongs to mortgage. Universal donee is belonging to the gift. Then you can see purchase, it is belonging to the sale, and holding over is belonging to the lease. Okay, so the correct code is going to be here. Which is the correct code? So let's see the correct code here. So for A it becomes 3, for B becomes it's 2, for C it becomes 1, for D it becomes 4. So 3 2 3 2 1 4. So this is the correct code here. Okay, let's see here which is the correct answer here. 3 2 1 4. So this is A is the correct option. Now next question, identification proceeding. Identification proceedings are provided under which section of the Indian Evidence Act? And the options which are given, section 8, section 7, section 9, section 11. And the right answer of this question is section 9. It is about the identification of the parade. So therefore it is with that. Okay. So now identification proceeding is with respect to section 9 of the Indian Evidence Act. Now moving to the next question. The question is here, which one of the following section of the TPA relates to oral transfer? So we have to see which provision of the TPA is belonging to the oral transfer. Now the options which are given, section 7, section 8, section 9, section 5. And the right answer of this question is here, section 9 of the TPA. It talks about the oral transfer. Next question, permission to investigate into a non-cognizable offence can be granted by, and the options which are given here, magistrate first class in any part of India, magistrate having jurisdiction to try the offence, magistrate in any part of the state, and D, the session judge. So the right answer of this question is that is the magistrate having jurisdiction to try the offence. Okay, so this is for that. You can refer section 155 of the CRPC. Okay, now next question, which section of the CPC prohibit arrest or detention of women in execution of decree of money? Okay, and the options which are given, section 56, 55, 59 and 60. And the right answer of this question is section 56. It prohibits that women in execution of decree, they would not be arrested. Okay, now let's see the next question. Which one of the following is not the essential element of sale? We have to see which is not the essential element of the sale. Now the options which are given here, that is the seller and buyer, without consideration, transfer of ownership, and none of the above. So which is the right answer of this question? If you just see, the right answer of this question is here, that is this one, without consideration. There must be some consideration because it is about the sale. Okay, it is not like a gift. Okay, next question, based on the assertion and the reasons. Okay, let's see assertion and reasons. The first one is, international organization plays a very important role in maintaining peace. And reason is this, countries have conflicts and difference with each others. And this is the way you can find the assertion and reasons. Okay, what you find that whether the assertion is going to justify by the reason. So see the first option, both A and R true, but R is the correct explanation of A. It is not the correct explanation because it is not answering that why they are going to have a play important role. Always there would be some kind of conflict, but it is not the reason that therefore they will go. Both statements are correct, A and R both are correct, but it is not the reason. A is false but R is true, it is also incorrect. Both A and R true, but R is not the correct explanation of A. Yes, this is correct, it is not giving the right answer. And D, A is true but R is false, it is incorrect. So the right answer of this question is here, which I am to highlight, that is C. Next question, in case of death of president while in office, the vice president can act as a president for a maximum period of what? 3 months, 6 months, 1 year and 2 years. So what is the answer of this question? When there is a death of the president, the vice president can be in the office for maximum of the 6 months. So this is the right answer. Next question. The next question is based on section 51 of the TPA. What it says that within the meaning of section 51 of TPA Act, the transferee. So now this section 51, it talks about the improvements made by bona fide holders under the defective title. So now what kind of the meaning of the transferee is there, and what kind of power he can. So transferee is not entitled to the value of improvements. The second option which is given here is entitled to the value of improvements. B. C. Has conditional entitlement to the value of improvements. And D. None of the above. So which is the right answer of this question? The right answer of this question is this one. That is the B. Okay. He will be entitled. Okay. So this is the way you can find. Next question is, which one of the following pair is correctly matched? So we have to see which is correctly matched here. Okay. Now let's start one by one. So my dear friends, if you just see the A option, Article 38 of the Statute of ICJ, sources of international law. Yes, it is correctly matched here. So this is the right answer. Okay, it is correctly matched. Now next question is here. In which one of the following sections of the Indian Evidence Act the fact showing the knowledge is declared relevant? And the options which are given here, that is section 9, section 13, section 8 and section 14. So the question is, which of the following section of the Indian Evidence Act says that the fact showing the knowledge is declared relevant? So answer of this question is, it is section 14 of the Indian Evidence Act. So this is the right answer. Moving to the next question. Under the Indian Evidence Act, how many witnesses are required for the proof of any fact? Okay, it is for the proof of any fact. And the options which are given here, at least 2, at least 5, not specified, and the D, at least 1. So which is the right answer? So there is no such specification is there in the Indian Evidence Act that how many witnesses is required. So therefore the C is correct here. Now the next question is here. Who can request the International Court of Justice to give advisory opinion on legal questions? And the options which are given here, any member of the United Nations, the General Assembly of United Nations, the highest court of justice of any nation, any permanent member of the Security Council. So who can seek the advisory opinion on any legal question from the International Court of Justice? And the answer of this question is, here, that is the B. Already this question was asked in the previous year, so it is a repeated question. The General Assembly of United Nations. Now the next question is, the greatest, who had said this? The greatest happiness for a greater number. Who had said so, and to which school it belongs? Okay, so or kind of concept it has. So you can see the option here. The analyst schools, utilitarian concept, realistic concept and positive concept. And the right answer of this question is here. The greatest happiness for greatest number, it belongs to the concept of this utilitarian concept, and it is made by whom? By the Bentham. Bentham has propounded this theory. So this is the right option. Now let's see the next question. The next question which is here, you can see here. Arrange the following in the chronological order on the basis of sections of the CPC and the provisions which are given: institution of suits, legal res judicata, legal representative, arrest and detention. And now we have to arrange it in chronological order. That means which comes first and which comes at the last. So let's do this. So let's see. So institution of suit is in section 26 of the CPC. Res judicata in section 11 of the CPC. Legal representative in section 50 of the CPC. And arrest and detention is the section 55 of the CPC. Okay. So now the first which is going to come, of course, the res judicata will come first. So the second, then the second, then after the first will come section 26. Then the third will come, that is legal representatives. And then fourth will come, that is the arrest and detention. So the right option of this question is here. You can see the D. Next question. Presumption as to electronic record of 5 years old is. The options which are given: conclusive proof, presumption of fact, then the presumption of law, and presumption of fact and law. So which is the right answer? And the right answer of this question is, it is only a presumption of fact. Okay, here you can use section 90A of the Indian Evidence Act here. Okay, the next question is also from the matching the list 1 and list 2. List 1 have the provisions and list 2 has the offenses. So it is about the essential elements of the offenses and the nature of the offense. So the first one is delivery of property. So when there is a delivery of the property, it would be always a case of the extortion, because you had kept that person in that threat and then that person is going to deliver the property. Taking of the property would be always a case of theft. You are taking away the property from someone's possessions. Entrustment of the property would be a case of the criminal breach of trust, because you had entrusted your property to someone and now that person has breached that trust. And the convertibility of property got innocently to one, and then it is a case of the criminal misappropriation. So if you look to this one, you can find that the correct code is here. Which is the correct code here? The correct code is here like this. For a delivery of the property, it would be the 4. For taking of the property, it would be 3. Entrustment of the property, it would be 1. And then the convertibility of property got innocently once, that would be the 2. So the correct code is 4 3 1 2. So this is the right answer. So which is going to be correct here? And you can see the right answer of this question is this one, C. Okay, the next question. Okay, now again you can see the question is from the matching the list. So many questions are coming. They had asked so many questions from the matching the list. Okay, again list 1 has the sections, list 2 has the provisions, and now we have to do a matching here. Okay, one by one. Let's start one by one here. Section 11 is about the res judicata. Section 26 is about the institution of the suits. Section 33 is about the judgment and decree. Section 35B is about the cause for causing the delay. So if you just see here, the right answer which is going to be here for the institution of the suits, it is going to be the 2. For res judicata, it would be the 1. Cause for causing the delay, it would be the 35B, that means 4. And judgment and decree would be the 3. So the right code is here 3143. Okay, and which is the right option here? Let's see here. The right option you can see here, it is in the B. Okay, now next question. Which of the following executes the decision of International Court of Justice? So which executes the judgment of the International Court of Justice, ICJ? And the options which are given here, you can see General Assembly, International Court of Justice itself, Military Staff Committee, and Security Council. So the right answer of this question is, already it is a question which was asked previously also. The right answer of this question is Security Council. It has no administrative duty to implement that one. Now the next question is here. Who among the following said that the witnesses are eyes and ears of justice? Witnesses are the eyes and ears of justice, and the options which are given here, Bentham, Fuller, Holland, and Kelson. So who was the man who said so? The man who had said so, it was the Bentham. So Bentham had said so. The right answer of this is the Bentham. Okay. Next question, again it is from the matching the list 1 and list 2. So you can see in list 1 certain provision, in list 2 certain sections of the CRPC has been discussed here. Now let's start one by one here. So let's start one by one. Content of charge in the, it is in the section 211. Judgment is in the 353. Assistant Public Prosecutor is in section 25 of CRPC, and reference to High Court in the 395. So let's start the proper coding here. Which is the proper code here? You can see The proper code, content of charge in the 4, that means at section 211 of CRPC. Judgment is in the 3. Assistant public prosecutor is in the 2, and reference to high court is in the 1. So 4, 3, 2, 1. This is the correct code. Okay. So let's see where is the correct code. So you can see the first itself. That is the A. 4, 3, 2, 1 is here. So this is the correct code here for this question. Next question. The next question is based on assertion and reason. So the assertion is this: A is a child of 9 years. He intentionally killed B. A may be proved guilty. Okay, so the age of the child is 9 years. And the reason is given here: child below the age of 12 years exempted from the criminal liability. Okay, so my dear friends, you know that the child who was below the age of 12 years, they are not getting exemption from the criminal liability. So this statement is incorrect. It would be depend whether he was capable to understand the nature of the act or not between the age of 7 to 12 years. So it is not absolute exemption. So what you find that here you can see A is false but R is true. It is not, this one is correct but it is not true. Okay, R is not true. Both A and true and R is the correct explanation of A. Yes, it is wrong. A is true but R is false. Yes, this is correct answer. Both A and R true but R is not correct explanation. It is also incorrect answer. So the right answer of this, the correct answer of this one is, which you all can find, that A is true but R is false. False. Next question. Which of the following case is related to the defense of necessity? And the options which are given here, you all can see the options. Case of McNaughton. This case belongs to section 84. DPP versus Wade, it is belonging to the drunken case. So this is not, it is not to be applied here. R versus Deadly Stephens. Yes, this case belongs to necessity. So therefore what you find that the right answer of this question is this: R versus Deadly and Stephens. Again, it is a very repetitive questions. So you can see the questions are coming from the previous years. So many questions are coming from the previous years. And then just move to the next question. If a witness who is unable to speak gives his evidence in writing in the open court, evidence so given shall be deemed to be. And the options which are given here: oral evidence, secondary evidence, primary evidence, and documentary evidence. So which is the right answer here? Any one of you, just give your answer through comment box. So the right answer of this question is, even though that witness has given the evidence in the writing, but it would be the case of the oral evidence. Okay. Moving to the next question. This question was already asked in the 2012, also in some other years. So this is a question which is a repetitive one. In which case the Supreme Court says the ownership is a preeminently a right. So in which case the Supreme Court had said that ownership is a preeminently right. And the options which are given here, you can see PT Munkanchya Reddy versus Revamma, if I pronounce rightly. B. Gangadhar versus BC Raj Malingam. Bisambar Dayal Chandra Mohan versus State of UP. And D. None of the above. So which is the right answer here? Any one of you? Just give me the answer. The right answer of this question is here. That is the B. B. Gangadhar versus BC Raja Lingam. So this is the right answer. Where Supreme Court had said that ownership is a preeminently a right. Okay. Moving to the next question. The next question is based on assertion and reasons. So let's read the assertion and reasons. The assertion says that United Nations Charter does not authorize United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state. Okay. So this statement which you find that it is the correct one. Okay. The principle shall not prejudice the application of enforcement measure under chapters 7 of the UN Charter. Yes, this is also a statement correct. But we have to see whether the assertion has the reason from the R. So the options which are given here, A is false but R is true. It is not. Both are correct statement. Both A and R true but R is not the correct explanation. Yes, there is no connection between these statements. It is not giving a reason for that. So therefore this is the correct answer. Both A and R true but R is the correct explanation. This is wrong. A is true but R is false. It is also wrong. So the right answer of this question is here. The right answer of this question is here. That is the B. Okay. Now moving to the next question, which is also based on assertion and reason. Now here you can see the assertion is admission is only prima facie proof, and reason is admission is not a conclusive proof, but it may operate as an estoppel. Okay. Now let's see which is the correct answer of this question here. Okay. A and both are true. A and both are true, but R is the correct explanation of A. My dear friends, both the statement, that assertion and reason, they are correct, but there is no a kind of nexus why it is to be called as a prima facie proof. So therefore it is not the correct. A is true but R is false, it is also incorrect. And D, R is true but A is false, it is also incorrect. And let's see this one, A and R both are true and R is not the correct explanation of A. Yes, this is the right answer of this question. Okay, so what you see, just see here, this is the right option. Okay, now next question. The next question is, in executing a sentence of solitary confinement, such confinement shall in no case exceed how many days at a time. So when you are having a solitary confinement, then it should not exceed a days in at a time. So the options which are given here: 1 month, 21 days, 7 days, and 14 days. And the right answer of this question is, you all know that the right answer of this question is 14 days. Okay, so this is the right answer. Now moving to the next question. The next question is also with the matching the list 1 and list 2. So list 1 says principal deposits his goods with an agent, so therefore you find the provisions. And the second is about the types of the possession. So let's start the matching here one by one. So let's see, principal deposits his goods with an agent. This is a kind of the immediate possession. Buyer purchase books from the shopkeepers. Okay, this is being called as a immediate possession. Okay, owner wearing his watch, it is being called as the corporeal possession because the watch is in the hands of the owner. Author's copyright is a kind of the incorporeal possession, so it is incorporeal possession. So this is how you can find. Now let's match this one. So A is here going to be with 1 because it is the case of the this case is about the immediate possession. Okay, he is getting immediately possession. Okay, B is case of the immediate possession, so therefore it would be 2. Owner wearing his watch, it is a corporeal possession, it would be the 4. And author's copyright is to be 3. So the right code is here. This is 1, 2, 4, 3. So which is the right option? So the right option which you all can see, it is the B here, 1, 2, 4, 3. Okay. Next question is here. Match the list first and 2. List 1 has certain provisions. List 2 has the provisions sections of CRPC. List 1 has the provisions and list 2 has the sections. So let's start one by one the matching. So let's start the matching here. So what you find, that inherent power of the court is going to be the section 482. Okay, so for D you can make right here 1. Okay, the next is here classification of the offense. Classification of the offense, it is in the first schedule of the CRPC. Compensation to the victim, it is in the 357. So you can write here also, please write 3. Classification is in the 4 and the language of the court is in the 272, that is the 2. So we have found the code here 2, 3, 4, 1. This is the correct code. So where you can find the answer? Yes, you can see here the B option which is given here. It is the correct code here. Now let's see the next question. Which provision of CRPC resembles with the habeas corpus writ? And the options which are given here: section 91, section 97, section 96 and section 93. So which provision of CRPC is like the habeas corpus? The answer of this question is section 97. Section 97 is like the habeas corpus. Moving to the next question. Now the next question is here with respect to section 2C of the Indian Contract Act, and it is about the definition of the promisee. So what is the definition of promisee? Promisee is the person who accepts the proposal, or promisee is the person who makes the proposal. Person to whom the proposal is made, a person who makes the promise. So it is about the promisee. That means the person who made the promise, who accept the promise. So therefore the answer of this question is here A. So this is the correct option. A is the correct option. Now the next question is here. The cardinal principle of criminal law, nullum crimen nulla poena sine lega, means. So what is the meaning of this maxim? Again I am repeating, nullum crimen nulla poena sine lege. What is the meaning of this maxim? And the options which are given here, you all can see. No crime of punishment can exist without pre-existing criminal law. Ignorance of fact is excused. It is not correct. Ignorance of law is not excused. It is also not the correct meaning of this. A man is presumed to be innocent until proven guilty. It is also not to be correct meaning. So the right answer of this question is here. You can see this one, A. A is the correct option. That is, no crime of punishment can exist without pre-existing criminal law. Again, we have to see the next question is here, which is not correctly matched. So let's highlight this one firstly. We have to see which is not correctly matched here. And you see on the right side, on the left side provisions, on the right side there are sections. So let's see which is not correctly matched here. So you see here, order of examination, section 138. Yes, it is correctly matched. Official communication, section 124 Indian Evidence Act. Yes, it is correctly matched. Presumption as to document 30 years old, section 90, it is also correctly matched. Presumption as to dowry debt, section 113A, it is not correctly matched because it is 113B. So the right option which is not correctly matched here, which we need to highlight, it is this D. Okay, so this is the correct answer for this question. Now next, again it is from the matching the list 1 and list 2. So list 1 has the provisions, list 2 has the sections. Okay, and all these provisions and sections are from where? From the TPA. Okay, so now the question of TPA is here. So let's start the matching here one by one. So the first one is the part performance is from the section 53A. So just write here 2. Conditional transfer is in the section 25 of the TPA. Just write here 4. Appointment of the receiver, which is here, it is 69A of the TPA. So write here 3. Implied contract by the mortgagor, it is section 65 of the TPA. So just write 1. So the correct code which you can find here, that is 2431. So let's see where it is there. So you just see this A, it is not this, it is not the correct code. B is 2431. Yes, this is the correct. Okay, now let's see the next question. The next question which is here, what was the theme of World Human Rights Day of 2021? They are not asking about the 22, because 22 is about the 23 is about the 22 was about World Millets Day, like that kind of the they had. So it is about 21. So the right answer of this one is, this is the B. Equality, reducing inequalities, advancing human rights. So this is the correct answer here. Okay. Now moving to the next question. The concept of double veto has been provisioned under which of the following article of UN Charter? It is about the double veto under the UN Charter. So let's start. The options which are given: Article 27, Article 24, it is not. Article 28, it is also not. Article 29, it is not. The right answer of this one, double veto, is Article 27. So this is how you can find the correct answer. The next question is here. Again, it is from the correct matching here. So we have to see which is not the correctly matched. So the oral transfer is in the section 9 of the TPA. Yes, it is correctly matched here. Vested interest is not in the section 21 of the TPA. It is not correct match. So therefore the right answer of this question is here, which you can highlight. vested interest. Okay, so this is the correct answer. Now next question is here. Again, it is from the matching the list. They had asked so much questions in this UPPCSJ. So let's see. The again it is about the matching of the list here. List 1 is as usual, they have the provisions. List 2 has the sections, and they all from where? From the Indian Contract Act. So let's start one by one matching here. So all these provisions are from the interpretation clause of the Indian Contract Act. So let's start one by one. So the voidable contract is in the section 2I. So you just write here 3. Contract has been defined under section 2H. So just write here 4. Void contract has been defined under section 2G. Just write here 2. And consideration has been defined in section 2D. So just write here 1. So then you can find here the code which is going to be correct here 3421. And the option which is given here, you can see the first one is correct. 3421. So this is the right answer. Now let's see the next question. So again it is from the assertion and reasons. Okay. Custom to have the force of law may not continuously be enjoyed. Okay. So this is not the correct statement. Custom represent common consciousness of people. Yes, it is correct, because customs made when the people have the common consciousness. Okay, so we have to see which is the correct answer here. So the A is true but R is false. The B is A is false but R is true, and both A and R true, but R is not the correct explanation of the explanation of A. So this is not the correct, because you can see already I had said this one. The A statement itself is false but R is true. So this is the right answer. Now next question. Which of the following statement are correct? Okay. And the options which are given here. Pleading to state material fact and not evidence. So when you are doing a pleading, you will do only material fact and not the evidence. Second is that amendments of pleading is provided in order 6 rule 16 of the CPC. So which is the right answer here? You can see here the amendment of pleading. The amendment of pleading has been given. You can see this order 6 rule 16 is having a provision with respect to suits on loss negotiable instruments. So it is not like this. Okay, so therefore what you find, only this statement is correct. So the right answer of this question is only 1. Okay, so this is the right answer. The next question is again the matching the list. Match list 1 and list 2. So list 1 has the sections and list 2 has the provisions of the Indian Evidence Act. So this is how you can see. And now let's start the matching of the list here one by one. So section 40 of the Indian Evidence Act, it talks about the expert opinion. So A is going for. Section 85 of this Indian Evidence Act, it talks about the presumption as to power of attorney. So therefore it would be the 3. Section 45A of the Indian Evidence Act, it talks about the opinion of examiner on electronic evidences. Therefore it would be 1. And section 23 of the Indian Evidence Act, it is about the admission in civil cases when relevant to. Therefore it is going to be 2. So the right code of this one 4312. So which is the correct code here? You can see here the first one A, it is not the right way. Okay, so it is incorrect. And B you can find 4312. Yes, this is the correct. So the right option is B here. Moving to the next question. The next question is also about the matching the list 1 and list 2. So in list 1 you can find the name of the organizations, and list 2 you can find the name of the headquarters. So let's start one by one and let's see which headquarters belong to which UN body here. So let's start one by one here. So let's start. UNESCO belongs to the Paris. Okay, it belongs to the Paris. ILO belongs to Geneva. IMF, International Monetary Fund, it belongs to the USA. ICJ, International Court of Justice, it belongs to Netherlands, that is Hague. So you can see here A is 4, B is 1, C is 2, and D is 3. So the right code is here 4123. And you see the first one is it is about 1 2 3 4, it is not correct. 1 4 3 1 4 1 4 2 3, it is also not correct. 2 3 1 4, it is not correct. And the last is 4 1 2 3. Yes, this is the correct option. Okay. Next question, which is also here from the matching the list, and there is the Indian Contract Act. Okay, now let's start the matching here. So as usual, you can see list 1 has the provisions, list 2 has the section. So start one by one here. So the free consent belongs to the section 14. Misrepresentation is belonging to the section 18. So just write here also. So B is 3, A is the 4, and coercion, which is given here, it is belonging to the 2. That means the here just write 2. And fraud is in the section 17 of the Indian Contract Act. So it is 1. So the correct code is here, that is 4321. 4321. This is the correct code. Okay. And let's see which is the correct answer here. So you see the A is A3B241. It is not the correct. A2B314. It is not the correct. C A1B2C34. It is not the correct. And D is A4. It is 4321. Yes, it is the correct answer. So this is the correct answer. Now moving to the next question. The question is here, consider the following activities and arrange them in chronological ascending orders as per relevant sections of the IPC. Okay, so we need to again to start from the first to the last one. Okay, and the provisions of the IPC which are given here, you all can see: sedition, house trespass, communication made in good faith, and public nuisance. So let's start one by one here. So let's start one by one. Communication made in good faith, it is in the section 93 of the IPC. Sedition is in the 124A. Public nuisance, it is given in the section 268, and house trespass in the section 442 of the IPC. So this is how you can find that. So the first which is going to come, that is the third. Thereafter the second will come the first. Then the next will come here, that is the fourth, and the last will come the third. So we have so that is, so yes, it is to be like this, just correct here. So the first will come the year, that is the communication in made in good, that is section 93. So it will come first. So third will come first, then first will come, then the fourth will come, and then the second will come. So this is how you can find. So third, first, fourth, second, we have to see the arrangement here. So what you can see here, A is not like this, so it is not, it is about first, third, fourth, it is not correct. B is third, fourth, it is also not correct. C is also not correct, and D is the correct because it's third, first, fourth, and second. So this is how you can find that this is the correct option here. So which section of CRPC is related to no unnecessary restraint? And the option which is given here, section 44, section 46, 49, and 43. The right answer is section 49. It talks about the no unnecessary restraint. Moving to the next question. The next question is an offence punishable with imprisonment for term exceeding 2 years. So when offence exceeds more than 2 years, this kind of the offence is going to be whether summon case, warrant case, both of the above A and B, neither of the above and A and B. So which kind of the case it would be there? It would be the warrant case. Okay. Next question which is here, which one of the following is correctly matched? And you can see on the left side the provision of the CRPC, on the right side you can find provision section of CRPC, on the right side you can find the provision of the CRPC. Now let's see which is correct, which is correctly matched here. So section 44 is about when arrest by magistrate, so it is not correctly matched. Section 41 of CRPC, it is about the arrest on this one, when police may arrest without warrant. Section 41 is when the police may arrest without warrant. Section 42, which says about arrest on refusal to give name and residence, yes, it is the correctly matched. Section 43 of the CRPC, it is about the arrest by the private person. So therefore, what you find that which is the correctly matched here, this is the only section 42 of CRPC which is correctly matched here. Now moving to the next question. Where lies the procedures? Where lies the procedure under the CRPC when corporation or registered society is an accused? And the options which are given here, section 306, section 304, section 319 and section 305. So which is the right answer here? The right answer of this question is the C, section 305. Next question, again it is from the matching the list 1 and list 2, you can see here, and this time it is from the CPC here, you can see. Now let's start the matching here one by one. Settlement of dispute outside the court, it is in section 89 of the CPC. Suits by or against the government, it is in section 79 of the CPC. Interpleader suit is in the section 88 of the CPC. Resistance to execution, it is in section 74 of the IPC. So this is how you can find that. The correct code is here, which you can find that 4324321. So this is the correct code. And where is the right answer? The right answer of this one you can see here in the B. This is the correctly matched here. Now next question is, by the Constitution 103rd Amendment Act, which one of the following clause was added to the Article 16 of the Constitution? So it is about the economical weaker section. Okay, and the answer of this question is very easy. You all know that the answer is Article 16 clause 6. Next question is, a barrister is instructed by an attorney or vakil that an important witness is dacoit. This is a reasonable ground for asking the witness whether he is dacoit or not. This illustration is based under the which section of the Indian Evidence Act? And the options which are given here, the first option, that is A here, it says that section 147 of the Indian Evidence Act. Section B says section 149 of the B says that section 149 of the Indian Evidence Act. C says section 145 of the Indian Evidence Act, and D says that section 153 of the Indian Evidence Act. So which is the right answer of this question? So this question which had been asked here, it is based on the illustration which is given in the section 149. Okay, just go to the illustration first, you will find that same illustration is given. So it is from section 149. Next question, when consideration and object of an agreement is partly unlawful under the Indian Contract Act of 1872, the agreement is, the options which are given here, that is the void, voidable, partly void and partly voidable, and D, none of the above. So when the consideration and object of an agreement which is void here, partly unlawful, then in that case the agreement which is there, it is going to be the void here. Okay, so the right answer is A. Okay, next is, which of the following pair is not matched? Okay, and now we have to see which is not correctly matched here. So let's start one by one here. The extortion in section 383 of the IPC, yes, it is correctly matched. Theft is in section 378 of the IPC, yes, it is correctly matched. Dacoity, which is given in the section 391 of the IPC, yes, it is correctly matched. And the last one is, that is robbery, section 389. It is not correctly matched because the robbery is given in the section 390 of the IPC. Okay, so this is not the correctly matched. So the right answer for this question is here, which is not correctly matched. This is the D. Okay, robbery is in the section 390 of the IPC. Moving to the next question, again it is from the which is not correctly matched. Okay, so here you can see here which is not correctly matched here. And now let's start one by one here. So section 2 clause 2 of the CPC is in decree, yes, it is correctly matched. Section 213 of CPC order, it is not correctly matched because order is in the clause 14 and section 2 clause 13 it talks about the movable properties. Section 2 clause 6 of CPC foreign judgment, yes, it is correctly matched. Section 2 clause 9 of the CPC, it is also correctly matched, which is judgment. So the right answer for this question which you can find here, which is not correctly matched here, that is the section 2 clause 3, because in section 2 clause 3 the movable property has been discussed, and 214 talks about the order. So it is not about the order, it is not about the it is only about the movable property, so it is not correctly matched. So now coming to the next question, which of the following suits are of the civil nature? Okay, so there is a list of the suits has been given, and this question was already asked. So the previous question was also the part of the previous year's question paper, and this question is also a part of the previous year's question paper. So let's start one by one here. The first kind of the suit which has been mentioned here in this question, that is the A, that is one here, suits related to rights of worship. Okay, then it is a kind of the suit which you find that which belongs to the civil natures. Okay, so this is correct. Suits for rights of hereditary offices, yes, it is also correct. Suits for recovery of voluntary payments or offering, yes, it is not the suits of the civil nature. Suit for specific relief, yes, it is correct. So the right answer, which is the right code, is here, which you can find here, that is the D, 1, 2 and 4. Okay, next question. The next question, under which of the following conditions section 12 of the TPA is not applicable? And the options which are given here, where the transfer is by the way of sale, B, where the transfer is by the way of lease, C, where the transfer is by the way of gift, and D, where the transfer is by the way of exchange. So the right answer of this question is, here, this is the B, where the transfer is by the way of lease. Okay, the next question which is given here, section 75 of the CPC provides for what? Issuing commission for getting opinion, appointment of executors and administrators, the C, settlement of disputes outside the court, and the D, all of the above. So this section 75 of the CPC, it is belonging to the issuing the commissions for granting the opinion. So this is how you can find that. So the A is the correct answer. The next question which is here, which of the following sections of the CPC deals with the transfer of decree for execution? So which is dealing with the transfer of decree for the executions, and the options which are given here, section 51, section 16, section 39 and section 42. And the right answer of this question is here, that is the section 39. Yes, you are right, section 39. Next question, again it is a matching of the list. So much questions from the matching the list. Again it is coming the matching the list. Okay, again you can find that it is from the Indian Evidence Act. Okay, so let's start do the matching here. So electronic records has been defined under the section 22A. Okay, so just write here 3. Opinion as to digital signature has been mentioned in section 47A. So just write 2 here. Proof as to digital signature has been discussed in this section 67A. So just write here 4. Presumption as to digital messages, it has been mentioned in section 88A. So just write here 2. So the right code of this one, 3, just a second, need to be clear here. Again, so electronic of records is going to be in the electronic record, that is in the 3. Opinion as to digital signature, which I had discussed here, that is in 1. Proof as to digital signature, it is in the 4. And presumption as to digital message, it is in the 2. So the correct code is 3142. Okay, so let's start here, which is the correct option here. You can see the correct answer is given in the D. So this is the correct answer. The next question, is here. Consider the following events and arrange them into chronological order. So again, we have to see which comes first and which comes is the last one. So the first one which is given, the cross-examination, examination in chief, and the third one is the re-examination. So let's start. So you all know that, my dear friends, the first will be the examination in chief. So second would be the first. Then there would be the cross-examinations. That is the first. That means the second here, okay, cross-examination. And the third which is going to happen, that is re-examination. So the proper code for here, that is 213. So you can see the A is the correct answer here. The next question. The question is this: which one of the following section of the Indian Evidence Act of 1872 is related with the presumption as to electronic agreements? So this is with respect to the presumption as to electronic agreements, and the options which are given here, you can see 88A, 85C, 81A and 85A, and the right answer of this question is 85A. This is the right answer. Moving to the next question. Order 20A of the CPC applies to which one of the following? And this order 22A will applies to which of the following? The options which are given: cost, appeal, withdrawal of suits and judgment. And the right answer of this question is here, that is the, which I am going to highlight, that is the cost. It is the correct. Next one, read the following statements carefully, and then we have to see which is true and which is false. Okay. The presumption of legitimacy of child is governed by section 112 of the Indian Evidence Act. B. Narendra Nath Pahari versus Ram Govind Pahari is a leading case on the legitimacy of a child born during the continuance of valid marriage. So in this case, both the statement which is given here, both the statements are the correct one. So what you find, that the right answer of this question is both A and B are the true. Next question. Which one of the following provision of the Indian Evidence Act is not matched? So we have to see which is not correctly matched here. Section 17, it is about the relevant fact. It is not correctly matched. So therefore the answer of this question is, this is the A, because section 17 talks about admission. It talks about the admission. Okay, so therefore it is not correctly matched. So this is the correct answer. Rest of the are the correctly matched. Okay, moving to the next question. The question based on the assertion and the reason. The statement is, agreement enforceable by law or contracts. Yes, it is correct. Agreement not enforceable by law are the void. Yes, rightly. Select the correct answer using the code given below. A is true but R is false, so it is not correct. A, both A and R true but R is not the correct explanation. It is also not, because unless until it is not going to enforceable, it is not going to contract. So therefore reason is there. So therefore the answer of this question is both A and R true, and R is the correct explanation of A, because unless until it is not enforceable, that means it is not going to contract, and void contract is not enforceable. So therefore there is a reasoning between the statement and the reason. So this is how you can see. The next question is here. Which article of the Constitution provides for the establishment of the Goods and Service Tax Council? And now you all know that, my dear friend, this question is very important. Already I had discussed to all of you in my one previous video. So what you find, that the right answer of this question is the article 279A. It talks about the GST Council. Moving to the next question, and again it is based on the assertion and the reason. Okay, right to education is fundamental right. Yes, it is correct. Our constitution has no provision for education before making the right to education as a fundamental right. Okay, so what you find, that this statement R is incorrect. So the right answer of this one, A is true but R is false, because we had provisions in the Constitution with the help of the Article 45, and then we had judgments also on the right to education, where the Supreme Court has declared that right to education is a fundamental right. Coming to the next question, which of the following section in the CPC deals with the settlement of disputes outside the court? So what you find that, again you can see this is given under section 89 of the CPC. So this is also a question which was already asked in the previous years. Moving to the next question. The next question is based on assertion and reason. Invitation to make tender is not an offer. Yes, good, it is right. A tender in response to such invitation is an offer. Okay, it is also good one. It is giving some kind of reasons. So what you find that there is a link between the assertion and reasons, and it is supporting this reason, supporting this tender, because the tender is in response to such invitation is an offer. So therefore what you find that the right answer of this question is A and R both are true, and R is the correct explanation of A. Moving to the next question, and the question is here, which is not an element of crime. So the options which are given here, actus reus, so then object, mens rea, and human being. So my dear friends, you all know that for the crime, human being, actus reus, and mens rea is required. Only the object is not required. So therefore, this is the correct option, object. Moving to the next question, and again it is a question from the matching the list. Okay, list 1 and list 2. List 1 is about the provisions, and list 2 is about the kinds of the offense. Okay, so let's start the matching here. Let's do this. So section 146 it is belonging to the writing. Okay, so for A you can write here 3. Section 340 is here belonging to the wrongful confinement, so you can write 4. Section 192 of the IPC is belonging to fabricating false evidence, you can write here 1. Section 383 of the IPC is belonging to the extortion, so you can write 2. So the correct code is here 3, 4, 1, 2. So which is the correct code here? Just go to this. You can see here the correct code is given here in the D. So this is the right answer. Okay. Next question is here. Which of the following instruments have been excluded by the application of section 137 of the TPA? That means Transfer of Property Act. And the options which are given here, you can see the stocks, shares, and the debenture. So what you find that all these things which are given here, the stocks, shares, debenture, they all are the excluded from the application of the section 137 of the TPA. So therefore the answer is this one, A. Okay. Moving to the next question. The next question is that an agreement with the meaning of which is neither certain nor is capable of being certain, this kind of the contract is being called as the void. You all know that. Okay, so when it is not possible to ascertain, then in that case it would be the void. Moving to the next question, and it is about the matching the list again. You can see so many questions had been asked in this paper from the matching of the list. So again it is from the CPC. Okay, so let's start the matching here. So if you see the adjustment which is here, the adjustment which is here, it belongs to, adjustment is belonging to the, adjustment is belonging to order 17 of the CPC. So just write here 2. Execution of decree and order, it belongs to order 21 of the CPC, just write 3. Plaint is belonging to the order 7 of the CPC, just write the 4. Affidavit is belonging to the order 19 of the CPC, just write 1. So the correct code is, which you can find that 2, 3, 4, 1. Okay, so this is how you can find here. And the correct answer which you can see here also, this is the A. This is the correct answer. Moving to the next question. The next question is here, under which one of the following article of the Constitution of India the Supreme Court has power to review its own decision? And the options which are given here, you can see 136, 137, 138 and 135. The correct answer of this question is here, that is the 137. So this is the correct answer. Okay. Next question is here. In November 2021, which of the following has launched a new journal, Solar Compass, to enhance research on the use of solar power? And the options which are given here, United Nations Environment Program, it is not. International Solar Alliance, yes, it is the correct answer. Okay, so this is the correct answer here. Next question is here, the expression disaffection. The expression disaffection used in the section 124A of the Indian Penal Code includes disloyalty and feeling of enmity. The second is disloyalty only. The third is all feeling of enmity only, hatred or contempt. So the right answer of this question is this A, disloyalty and all feeling of enmity. This is the right answer. Now next question is here, Russian invasions on Ukraine violates which article of the UN Charter? Okay, so what you find that, for that you can see, refer this article which is given here, Article 2 Clause 4 of the UN Charter. So it is to be called as infringement of the Article 2 Clause. Article 2 Clause 4 says about this prohibition of. So it is against the use of force and use of threat in the international relations. So this is how it is violation of the Article 2 Clause 4 here. Moving to the next question. The next question is about, for the validity of the contract, which of the following elements are necessary? And the options which are given here, you can see intention to create legal relationship. Yes, it is the correct option. Okay. Then knowledge of the offer. Yes, it is also to be there. Writing of the agreement is not essential. Acceptance of the offer, it is also essential. So what you find that here, you can find that the only this 1, 2 and the 4, they are the essential. Okay, so therefore the answer of this question is here, the answer of this question is here 1, 2, 4. This is the correct. Now moving to this question, which of the following is an exception to the maxim UB just EB remedium? Okay, and the options which are given here, you can see positive rights, perfect right, imperfect right, negative rights. And the answer, right answer of this question is this one, imperfect right, because imperfect rights has no any remedy kind of the remedy would be available. The next question is here, arrest by match the list again. Okay, now arrest by magistrate, arrest by private person, arrest how made, arrest by police officer without warrant. So what you find that we all need to find out that the correct matching here. So if you just go to this one, this time you find the arrest by police officer without the warrant. So this kind of the provision is given in the section 41 of the CRPC. Okay, moving to the next one, arrest by magistrate in the section 44 of the CRPC, arrest by private person, it is in section 43 of the CRPC, and arrest how made, it is in the section 46 of the CRPC. So if you have to just made the, if you just need to make a code here, you can write here that for D, the right option is here the 1. Okay, arrest how made, that is for 4. Arrest by a private person, it is in the 2, and arrest by the magistrate, it is in the 3. So this is how you can find that 3, 2, 4, 1. And where is the right answer of this one? You can see here the B option is the correct answer, 3, 2, 4, 1. Moving to the next question. The next question is about legal terminology of res nullius. What is the meaning and for what purpose it is being used? Okay, so the options which are given here, you can see here, the first is property of certain person, then ownerless property, property of corporation, and none of the above. So this question is from the jurisprudence, and the answer of this one, ownerless property, the property do not belong to anyone. The next question is here, no appeal shall lie from a decree passed by the court with the consent of the parties. It is provided by which section of the CPC? And the options which are given here, you can see section 96 clause 4, it is not correct. Section 96 clause 2, it is not correct. And section 96 clause 3, yes, it is the correct. So the right answer of this question is this one. Okay, moving to the next question here. The next question is about matching the list again. Okay, and now this time from the Indian Constitution. You can see this is the from the Indian Constitution. Okay, so let's start the the matching here. So this the distribution of the legislative power, it is from the Article 245 to Article 255. Organization of village panchayat, it is in the Article 40 of the Constitution. Extension of executive power of the Union, it is given in the Article 73, and parliamentary privilege in the 105. So you can write here D, for D it is 4, for C it is 2, for B it is 1, for 1 it is 3. So the 3, 1, 2, 4, this is the proper code here. Okay, and where the answer is A, you can see here. Okay, now the next question is, which article of the UDHR grant right to life and liberty and security of person? So my dear friends, if you see here, this question is not coming from the UN. It is coming from one of the international covenants or declaration that is being called as the Universal Declaration of the Human Rights. So for that, it is in the Article 3. So this is a very surprise question. Normally they do not ask questions from the UDHR, but this time they had asked question. So it is Article 3 of the UDHR. Moving to next question, which section of the CRPC has provision for the cancellation of the warrant? And the options which are given here, section 69, yes, it is not that section. Then the next option is section 70, yes, it is the right answer. So the right answer of this question is this one. Okay, next question is based on assertion and the reasons. So let's see the assertion and the reasons here, and then let's see what happens. Now inquiry precedes trial, yes, it is correct. Trial is the third stage of the criminal proceeding, yes, this is also the correct. And then if you just go to this, A is true but R is false, it is not the correct. A is false but it is R is true, it is also not. Both are true but R is not the correct explanation, no, it is also not, because inquiry precedes the trial. So what we'll find that firstly the inquiry will come and then the trial will come. So there is some relation between these two, and therefore this option B which is given here, it is the correct, because after the inquiry the trial will start. So there is a connection, and therefore it becomes a third stage of criminal proceeding. Moving to the next one. Now it is about the matching again. You can see correctly matched. So we have to see this one, which is correctly matched. So interpleader suit, yes, it is in the order 35 of CPC. Judgment and decree is in order 20 of the CPC, yes, it is also correct. Withdrawal and adjustment of CPC is also in order 23. Payment into court, it is not in order 21. Order 21 talks about the execution of the decree. So therefore what you find that only these 1, 2, 3, they are the correctly matched. So therefore the option is D is correct here. Moving to the next question. Again, this question is also from the matching the list. Okay, now the options which are given here, you can see here from the Constitution here, you can find here Article 43, 42, 44, 50, and the provisions are given here. Then let's see which is the correctly which is the correctly match going to match correctly here, and which is the proper code here. So just see here Article 43. Article 43 is about living wages for the workers. Okay, then just come to Article 44. It is about the Uniform Civil Code. Then if you just come to this Article 50, it is from the separation of judiciary from executive. Article 42 is about the provision for just and humane condition. So this is how you can find. So you can write here on the left side of the list 1 the answer which is correct here. So 43 is about the A is 2, 42 is about 3, 44 is about 4, 50 is about the 1. So 2, 3, 4, 1. So this is the correct option here. So if you just go to this, you can find the correct answer is here in the C category. Okay. Next question. Which one is the correct sequence from the following as implied in the Indian Contract Act? So we have to see the correct sequence. Okay, which comes first and then what comes the next. So this is how we need to go to this one. Okay. So the sequence which has been given, you can find that offer of proposal, contract, promise, agreement, and acceptance. So this is how you can find here, and which is the correct the sequence here. Just let's start one by one. So firstly, what you need to do, there must be the offer of proposal. So this is the to become first. So A is to become is required to come first. Then after the proposal, you will accept that proposal. Then the acceptance will come. Once you did your acceptance, you gave your acceptance, then you made a kind of the promise. So therefore the C will come the next. And once it becomes a set of promise from both the side, it becomes the agreement. Then that means the D will come the next. And then it is going to be as a contract at the last. So B will come at the last. So the last. So what you find that the correct code is which you can find here A, C, D, B here. And you can see here the B is the correct. The B is the correct option. Okay. Moving to the next question. So this question you can see again it is a matching the list. So it is from the IPC. So let's start. Causing death by negligence. It is in the section 304A of the IPC. Dowry death it is in the 304B of the IPC. Abatement to suicide it is in the 306 of the IPC. Attempt to commit suicide it is in the 309. So what you find that for A you can write here the 3. Can write here 3. For dowry death you can write here 4. For the abatement to suicide you can write here 2. And attempt to commit suicide you can write the 1. So 3, 4, 3, 4, 2, 1. This is how you can find the code. And the right option which is here you can find here, that is the A, 3, 4, 2, 1. So this is the correct code here. Moving to the next question. A is a national champion of swimming in the pond. He could have saved the child but did not do so. The child drowned. A is guilty of. So he was champion of swimming but he has no mens rea. Therefore what you find that despite he is not ready to save that child, he has committed no offense. So this is the right answer here. Okay. Moving to the next question. Which of the following pair is not correctly matched? So we have to see which is not correctly matched here. Okay. Now what you find that the Article 79 is talking about the Constitution of the Parliament. Yes, it is rightly at short title of the Constitution in Article 1. It is not correct because it is about the Union of India. United States has been discussed. So it is incorrect. So which is not correct match here. So this is not correctly matched. Moving to the next question. Subject to subsection 2 of section 64 of the CPC, a private alienation of property after attachment is the options which are given here void, improper, lawful and voidable. And the correct answer of this one is, this is the subject to section 2 of section 64 of CPC, a private alienation of the property after attachment is going to be the void. Okay, so it is how you find that it is void. Moving to the next question. So this question is also from the matching the list here. Okay. International Day of the Education is belonging to the 24th January. So just write here 1. World Environment Day is belonging to the 5th June. So just write here 4. World Teachers Day, which you can find here, it is belonging to the this one 5th October. Okay. And then International Mother Tongue, it is on the 21st February. So this is how you can find this. So it is on the 3. So it is the 2. So 1, 4, 2, 3. So where you find this answer? 1, 4, 2, 3. The right answer of this question is here. This is which you can find here, the D. Let's see the next question. Disclosure of the identity of rape victim is punishable under the following section. Which following section of IPC? It is a very repetitive question. So this is section 228A of the IPC. Okay. Moving to the next question. Which of the following is correctly matched? So we have to see which is correctly matched here. So you can find that Indian Contract Act has been discussed, and then the provisions of the Indian Contract sections has been discussed here. So we have to see which is the correctly matched here. So just go to this, you find that this option which is given here, responsibility of finders of the good, it is only correctly matched. Rest of them are not correctly matched here. Okay, the case of Tudor versus Atkinson is related with which kind of the subject matter. So what you find that this is belonging to the case which is here to the privity of the contract. Okay, so this is how you can find that this case belong to the privity of contract. Next question is here, point out the correct answer. An agreement enforceable by law is the contract. So what you find that, yes, this is the correct statement here. Moving to the next question. Again, this question is about the matching the list here. You can see here, doctrine of subrogation, doctrine of consideration, doctrine of accumulation, doctrine of lis pendens. So now let's start the matching here. So A, which is about the doctrine of subrogation, it is in the section 92, section 92A. So just write here 4. Okay. Then doctrine of consideration, it is given in the section 61 of the TPA. So just write here 3. Then doctrine of accumulation, it is given in section 17 of the TPA. So just write here 1. Doctrine of lis pendens is given in section 52 of the TPA. So what you find that it is right here the 2. So 4, 3, 1, 2. So where is the right answer of this question? You can find here this option B is the correct. Now coming to this question, and it is about the statement. When transfer of property by the owner is dissented under section 30 of the transfer of property, under which circumstances compensation should be given to disappointed transferee. Okay, so what to find that from this section one question was already asked in this paper here, and now they are asking again here. So the option which is given here, where the transfer is gratuitous and the transferor has before the election died or otherwise become incapable of making a fresh transfer. Okay, so yes, this is the one thing which you can find that the under this circumstances compensation should be given, where the transfer is gratuitous and the transferor is before the election is alive. So what you find that this is not the condition. Then second, when the transferor is for the consideration and the transferor has before the election died, yes, it is also a case for the compensation. When the transfer is for consideration and the transferor is before the election alive, so yes, this is also about that one. So therefore the answer of this question is here 1, 3, 4. So this is the question which was not asked earlier. Now coming to the next question, again it is from the matching the list here. Okay, and now you can see we have to match the list here. So let's start one by one here. Okay, so you can see here this anticipatory bails is belonging to the 438. Okay, cognizance on complaint is belonging to this 190 of the CRPC. Language of the court, again this section was again asked 272. Security for good behavior from a habitual offender, that is 110. So what you find that the code which is going to made here, that is the 3, 4, 1 and 2, and the right answer which you can find here in the C. So this is the correct answer. Moving to the next question. Again the next question is about the matching the list here. You can see, so it is from the Indian Constitution. Okay, so let's start the matching here. The first is here which you can find here, equal justice and free legal aid. It belongs to the article 39A. Okay, Constitution of the Parliament, it belongs to article 79. Again this article was already asked, so you can find that questions having some nexus with the previous question which had been asked here also. Then separation of judiciary from executive, Yes, it is from the Article 50. Fundamental duties in from the Article 51A. So this is how you can find this one. So for A, which you find here, that is the 3, 4, 1, 2. So this is how you can find this. The correct code is going to be happen 3, 4, 1, 2. And the right answer of this question is here. You can find in the C. So C is the correct answer. Next question. The Quad Summit was held. Where it was held? At which place it was held? And the right answer of this question is the Quad was held in the Japan. So this is how you can find out. So Japan was the country where it was held. Now the next question is that who has authority to fix scales of monthly allowance payable of substance of judgment debtors? So who is having this authority? And the answer of this question is here, that is the state government. Next question which is here, match the list first and list 2 and select the correct answer. So what you find that again there is a matching of the list, and let's start from 1 by 1. So hostile witness is given under section 154. So just write here 3. Dying declaration which is given here, it is belonging to the Article 32, section 32 clause 1, okay, of the Indian Evidence Act. Refreshing the memories, it is in the 159 of the Indian Evidence Act. Leading question is in the section 141 of the Indian Evidence Act. So what you find that the code is 3214, and the right answer which you can hear, that is this is the A. A is the correct answer. Moving to the next question. The question is here, A owes B rupees 1000, but the debt is barred by the Limitation Act. A signs written promise to pay B rupees 500 on account of the debt. This is whether it is going to be a contract, it is going to be agreement, wired agreement or wired agreement. So this is going to be the contract here. So this is the right answer. Provision regarding adjudication of claims and objections to attached property is given under which order and rule of the CPC? So it is given in this order, order 21 and rule 58 of the CPC. The concept of living law was propounded by whom? Who was the man who had said this, that it is the living law? And the right answer of this question is living law was propounded by the Ehrlich. So this is the correct answer. Next answer question is here. Given below are two statements. One is labeled assertion and other is reason. So let's start the assertion and reason here. And you see here, the International Court of Justice has power to decide cases on the basis of equity. So yes, it is correct one. Equity is one of the principles of law recognized by civilized nation. Yes, it is also correct one because it has been recognized. Therefore, the International Court of Justice is taking the help of the equity here. So therefore, what you find that there is a nexus. That means both statement A are true and R is the correct explanation of A. So this is the correct answer here. Okay. Moving to the next question. The next question is also again the matching the list you can see here. Okay. Now let's see here. Right against exploitation, which is given here. It is belonging to the which article of the Constitution? It is from the Indian Constitution. So you can see here, right against exploitation is in Article 23 and 24. Just right here 3. Equal justice and free legal aid. Again you can see this kind of the article was asked again here. So you can write 1. Power of president to grant pardon. It is the 72. It is correct. The seat of Supreme Court is in the 30. So you can write here the 130. So you can write here 2. So this is how you can find this one. So the correct code is 3, 1, 4 and 2. So where it is this? So you can find that in the A option, the same code 3, 1, 4, 2. Next question is here from the CRPC. Okay, it is from the CRPC. A session judge under section 9 clause 2 is appointed by whom? And the options which are given here, you can see the options. The district magistrate, state government and the High Court. And the right answer of this, you all know that this is the High Court. Next question is here. Which one of the following section of the CRPC provides that no judge or magistrate shall try the case in which he is personally interested? So this is how you can find that. And the answer of this question is here section 479. It says that a magistrate can't be a part of a case where he has personal interest. Okay, moving to the next question, it is based on the assertion and reason. And now here you see here, the Indian Penal Code contains certain exemptions from criminal liability. Yes, it is correct. These cannot be universal criminal liability. These cannot be universal criminal liability in all circumstances. Yes, of course they have exemptions, and yes, therefore you will find that, but this can't be a criminal liability in all circumstances. So therefore there are some regions also between the assertion A and R, and they are explaining rightly. So therefore the option which is correct here, this is the A and B are true, and R is the correct explanation of A. Moving to the next question. The next question says A commits theft on the property in the possession of B, and while committing theft, A has loaded a pistol under his garment, kept for the purpose of hurting of B in case of if B resists. So this was a question was already asked in the previous years, and now which kind of the offense A has committed under the section of the IPC, under which section of the IPC has committed the offense. So this is going to be section 382 of the IPC. The evidence may be given of the following facts: fact in issues and relevant facts. So which is the correct answer here? So what you find that the evidence can be given on both. So that means A and B, 1 and 2. So this is the correct answer. Now arrange the following in the chronological or ascending order as per the relevant sections of the Indian Penal Code. So this is how you can find here. So let's start arrangement of this one by one here. So you can see the public servant is section 21. Okay. And then come to the dishonestly. It is in section 24. Okay. Fraudulently is in section 25 of the IPC. Okay. And the document is in the section 29 of the IPC. So if you just look to this, the correct answer is going to be here in the chronological order: 4, 3rd, 2 and 1. And where is the answer? The answer is here. You all can see. Okay. Moving to the next question. Which one of the following is correctly matched? Okay. Now let's see here the options which are given. Section 354C of the IPC, and this is which is here, it is not correctly matched here. So 354C is about the voyeurism. It is not correctly matched. 124A of the IPC is about the sedition. 350 of IPC is about the criminal force, and only this is correctly matched. So therefore what do you find that which is correctly matched? The correctly matched is the 354C. Okay. Moving to the next question. Now again this question is matching the list. Okay. List 1 and list 2. So now let's start the matching, and it is from the TPA. Okay. So let's start. So the fraudulent transfer is belonging to this section 53 of the TPA. Election when necessary, it is belonging to this section 35. Okay. Rule against perpetuity is given in the section 14. Conditional transfer is in section 25 of the TPA. So if you just have to make a code here, so you can see 4, 2, 1, 3. So this is how you can find. And where this code lies? This code lies here in the D. So D is the correct answer. Moving to the next question. The subject of criminal procedure falls which one of the following list of the Constitution of India? Union list, state list, concurrent list. So under which list it falls? Yes, it falls in the concurrent list. Devilal Modi versus STO. AIR 1965. This case is of the 1965 is relating to which kind of the matters of the CPC? Now the answer of this question is here, that is the constructive res judicata. This case belongs to the constructive res judicata. Moving to the next question. Again the question is from the matching the list. So many questions are from the matching the list. Okay. And now again we have to do the kind of the matching of the list here. So the list 1 which is about the execution of decree here. So start from the execution of the decree here. So what you find that execution of decree is in the section 38 of the CPC. Letter of request is in the section 77 of the CPC. Okay. Legal representative is in the section 50 of the CPC. Institution of suit is in the section 26 of the CPC. So what you find that the right answer of this question is here A. Okay. Because if you just make a code here, you find that 4 for because executive of decree is coming in the 4, letter of request is coming in the section 77, then it is 3, and then the legal representative is in section 50, so it would be 1, and the institution of suit would be in section 26, then it would be 2. So this is the right answer. A is the right answer for the question number 144. Moving to the next question. The next question is again matching the list. Now let's start the matching the list, and this time it is question from the Indian Evidence Act. Okay, so let's start the question. Now the question which is here from the primary evidence. So primary evidence is in the section 62. So for this you can write here the 3. Okay, public document has been defined under section 74. So just write here 1. Private document has been defined under the section 75 of the Evidence Act. Then write here 2. And secondary evidence is discussed in the section 63 of the Evidence Act. Then write here 4. So the answer is here 3, 1, 2, 4. So it would be like 3, 1, 2, 4. So this is the correct answer here. Okay, which is A. Next question which you can find here, under which article of the UN Charter the members of the United Nations have agreed to abide by the decisions of the Security Council? And the right answer of this question is here, this is Article 25. Now this question is also repetitive one, and the second question is also repetitive one. It was already asked. The official language of International Court of Justice. So the right answer of this question is this French and English. It is the official language. Which article of UN Charter provides for the expulsion of the member states? So again, this is a question which was already asked in the previous years, and the right answer of this question is this Article 6. It talks about that expulsion of the member states. The next question, which of the following is not correctly matched? So the answers which is given here, options which are given here, we have to find that which is not correctly matched. So power of High Court to make rules under section 477 of CRPC, yes, it is correctly matched. Then resumption of inquiry or trial under section 331 of CRPC, yes, it is also correctly matched. Appeal in case of acquittal under section 378 of CRPC, yes, it is also again matched. Then trial by High Court section 473, it is not correct match, because 473 is talking about the extension of period of limitation in certain cases. So this is not that. For the trial by High Court, the section is 474 of the CRPC. Moving to the last question of this UP Judiciary of 2002 Prelims examination. So the last question which we are having, that is the based on the assertion and reason. And this is last question from the UP Judiciary Prelims of 2022. And the assertion which is given here, that is transfer in perpetuity is allowed for the benefit of the public. So that is how you can find here. And this is not the reason. This is not the proper statement, sorry. It is not that. But the reason is welfare of public at large is above the welfare of individual. Yes, it is correct. Okay. So what you find that the R is true but A is false. So which is the right answer of this question? The B. B is correct answer. So with this, my dear friends, I have finished this question paper, solved this question paper of UPPCS J. But the sources which I had taken, it is from the Bayer Act, it is from the provisions which I have come across based on the Bayer Act. So therefore I request all of you, please verify that how much it is correct. But I have found that most of them are very much correct. But again, disclaimer, if any kind of confusion, any kind of question, queries, please, I invite all the questions, suggestions, queries, please do the comment in the comment box. And if you want more elaborative discussion on this paper, we can have, but please put your comment so that we can make the videos. With this, I am very much thankful that you are watching this video, and we will make such kind of videos in future also of the previous year's question paper from the other states. So please subscribe my channel if you're first on my YouTube channel, and not only subscribe but also share with your friends. Okay, so with this note, again I am thanking to all of you. We will meet with another video. Till then, bye bye.